assume, and I'm willing to have you assume, Ben Lupo's a bad person. He intentionally directed someone to put brine down a sewer. He shouldn't have done that. He shouldn't have done that. But are those actions to be imputed to D&L Energy simply because he's an officer of the company or was an officer at the time? I think that you will see when you take a look at certainly the case law that's been submitted, that's not the case. I think, let's start with the law, because I think that forms the context of how we're going to deal with this act that we all will agree was reprehensible. Shouldn't have been done. We don't know why he did it. Perhaps we will not know until his trial on the federal level, and he is able to put forth any defenses he has, and a jury of his peers may decide whether he's actually guilty or not. We don't know that. But let's look at the context of how we decide when a person acts. How is that affecting corporations that that person may have some relationship to? In every case cited in the division's brief, the issue was whether an employee or an officer could be held liable for the acts of the company, so-called piercing of the corporate veil. Think about that. It's absolutely backwards to what we're here to decide. We're not here to decide whether Ben Lupo is guilty or liable for his actions. He wasn't issued the order. The order was issued to D&L. Yet in every one of those 17 cases that was attached to the brief of the division, the issue was if the corporation pled guilty or was found guilty, would that guilty plea implicate the officer? And of course, in the state of Ohio, we've indicated in our briefs, there's a concept called piercing of the corporate veil. The Ohio Supreme Court has a landmark decision, the Belvedere condominium case. There's 4 requisites that the governmental agency must prove prior to piercing the corporate veil, but we're not piercing the corporate veil. Ben Lupo, in all likelihood, is liable. And so the case law that's being submitted to you by the division is backwards. It doesn't show you under what circumstances would an employee or an officer's actions be imputed to the company, not the other way around. And yet there's a whole body of law that was never raised in the division's brief, was never raised in the order issued by the chief, that looks at those circumstances in which an act of an employee or an officer is to be imputed to the company. And there's some examples of this. I took it right out of kind of a primer on business law. Here's some classic examples of how you make a determination whether an officer or an employee, his actions, if it violates the law, should be imputed to the company itself. Let's presume that we have an officer of a company. Let's just make him president of the Cleveland Clinic, just for the heck of it. You know, he's driving home, he's late for dinner, he exceeds the speed limit, clearly violates the law intentionally and injures another motorist. The officer, president of the company, is clearly liable for his own personal actions. He violated the law. His actions caused damage to another human being. He is held responsible for that. That's not surprising. But is his company, the Cleveland Clinic, responsible for his actions driving home? Of course not. And the reason that they're not is because he wasn't acting within the scope of his employment. And we certainly wouldn't if the state of Ohio took that president's license away for driving. Would it have been proper for them to take the license of the Cleveland Clinic away and tell everybody to go home? Of course not. Because the president driving and violating the law was personal to him. He was not acting within the scope of his employment. Now let's just change the